Hello, everyone. Thank you so much for joining us again on our education webinar series. We are more than happy to welcome Jennifer Locke of River Rock Law today to talk about probate for realtors. I know as a broker, this is a topic I get asked all the time, so I'm really excited to have a true expert come and divulge her knowledge to all of you. So without any ado, here is Jennifer Locke. Before she starts diving into her presentation, just a couple housekeeping items. Please, if you have any questions, type them in the Q&A box at the bottom. I will ask them at the end of the presentation or answer them live while we go if it gets answered that way. Otherwise, Jennifer, the floor is yours, and thank you so much.
Wonderful. Well, thank you so much, Alex. I'm just going to go ahead and share my screen here and get started with my first slide on my PowerPoint. So today's topic is practical probate advice for realtors. And one of the reasons I enjoy doing this presentation so much is because there's so much misinformation out there. And so hopefully you'll get not just a clear concept of what the current law in Alberta is, you'll also get some helpful tips and tricks. And yes, I will be providing the slides to Alex so he can disseminate those to you so that if in a future deal, you're wondering what you should be using for terms and conditions, what the timeline looks like, you'll have that as a resource. So without further ado, here's our practical probate advice for realtors. So some of the things that we're going to talk about today is just what is a grant of probate, what you should check for when it comes to buying or selling with a deceased person's property, helpful terms and conditions to put in the purchase contract, and this beautiful, magical interim court order permitting sale of a house before a grant is issued. This is really underutilized. And this is one of the reasons why I like doing presentations to brokerages is to say this option exists in Edmonton and Calgary, because of course, those are our two biggest cities in the province. And as a result, have the most estates and therefore the longest delay periods when it comes to a grant of probate being issued. And finally, if we have time, we can touch on powers of attorney for people with dementia, because of course, when you're selling a house by way of a power of attorney, there's a few extra things that have to happen in order for that transaction to go smoothly. So first thing, just what is a grant of probate? Well, a grant, simply put, is a court order. And if you really want to impress a lawyer, know the difference between probate and administration. Probate is when there is a will of a deceased person. Administration is when there is no will. And all the grant of probate is the court validating the last will and testament of the deceased person, saying, yes, this is in fact the will. Yes, the personal representative, or the more antiquated term is executor, named in the will is the person in charge, signed by a justice of the Circuit Court of Alberta. Okay. And that's the idea. The personal representative and the executor, of course, is the decision maker in charge of dealing with that deceased person's estate. Now, the big thing, of course, that we often see is delays, right? And so you see people saying, well, I don't even know if we should even start discussing matters with a realtor because it's going to take so long to get a grant of probate. And that is true, unfortunately. One of the things that, I usually try and touch base with a family member when they reach out to me and say, I don't even know the first thing about a grant of probate, what do I got to do? Is saying, well, you're going to have to wait for a bit, because the usual wait time is probably about 6 to 12 months from beginning to talk to a lawyer to actually receiving the grant of probate. And as you guys can understand too, 6 to 12 months is a lot of time for a house not to be moving, to be sitting empty, okay? And of course, the problem with the delay, as you see here, is that we're dealing potentially with mortgage payments, taxes, utilities, insurance. And one of the big things, of course, is that if the house is vacant and there isn't a family member or somebody else nearby that can check in on the house, you need to get a vacancy rider, and not all insurance companies will provide a vacancy rider. The reason being, under the Insurance Act of Alberta, if a house sits empty for more than 30 consecutive days, it's considered a material change in risk. Meaning, if you have somebody who goes in and vandalizes the property or burns it down, guess what? The insurance company isn't paying out that claim because the insurance company says, well, we didn't know that that was vacant. That's a huge liability for us. So too bad, no insurance. Okay. And the other thing too is even if you go out and get a vacancy rider, it's only usually for a limited period of time. It might be for 3 months, it might be for 6 months. Doubtful you'll find an insurance company that's willing to insure a vacant property with nobody checking on it for an entire year. Okay. And the bottom line is that all of these extra expenses add up, which means that there's less money in the pot for the beneficiaries at the end of the day. So here's basically the solution to try and save the estate and the beneficiaries some money. So as of June 15th, 2022, there is a brand new web-based platform when there is a will and when you have a personal representative or executor that is resident of Alberta and there are beneficiaries all over the age of 18. Okay, those are the 3 requirements. We can actually do an online submission to surrogate courts. This is brand new, and this is really exciting to you because, as you've guessed, when it comes to the court process, it's a slow-moving machine. It's slow to embrace technology. So this is really, really exciting. And for the first 6 months of this, there were some little kinks to work out, but mostly it was fantastic. I've gotten quite a few grants through this new system. I love it. And the turnaround is extremely fast. I've gotten grants in a week to 3 weeks to a month. And the reason why we're seeing the time go up is because, of course, more lawyers are embracing this. And actually, the truth is that if you're a lawyer, you have to use this process. So saith the courts. But honestly, it's for the better. Okay. Now, unfortunately, if you don't fit those criteria, you have to go the paper route. So still, I mean, there's a solution. It's just not as slick as the online platform. So the interim court order that I want to talk about allows for the sale of property, even though the court is still reviewing the grant of probate, okay? So one of the things that has to be done is that there has to be at least a file opened with the courts. So that means that the client, as in the personal representative who's going to be dealing with the deceased estate, has met with the lawyer and the lawyer has been able to do an initial application to the court with at least bare bones information. We need that surrogate court file number in order to get the court order. And I can't stress that enough, okay? The other thing that has to happen is that in the court order, there is a paragraph that confirms that the balance of the sale proceeds, so after, of course, commission, legal fees for specifically the sale of the property, and of course, any mortgage payment, any writs of enforcement, et cetera, that sort of thing, any net sale proceeds remaining have to stay in that lawyer's trust account until the court actually then issues the final grant of probate. But at least the house is sold. There, of course, is, new buyers in it. They're enjoying the place. The sellers, being the estate, are extremely happy because they're not paying any more utilities, any more property taxes, any more insurance. Mortgage payments are done. It's perfect. So the idea, of course, is that the purchase has to be unconditional, meaning that the buyers have waived all conditions. So financing and inspection, those have to be removed. And so I want to make it clear, if you're going to go through this process, your client will definitely have to engage the help of a estate lawyer. And so what can you do as the realtor to help with this process? The first thing is to find out if there is a will and try to get a copy of it. You can also get this court order even if there isn't a will, but again, probate meaning will, administration meaning no will. Then, of course, you're going to figure out who the PR, the personal representative, is and see if they have an estate lawyer. If not, hopefully you can help them find one. It's great if you can find a lawyer that is familiar with both estate law and real estate. That's the sweet spot there. And so, you're able to then advise them that the estate's going to be able to save a lot of money if they go ahead with this court order, because it helps us wrap this aspect of the estate up earlier, and there's not going to be monthly expenses. This is especially tricky if you're dealing with a house rich, cash poor estate. So if you have a deceased person that was maybe just getting OAS and CPP, but they still have a mortgage, well, it's probably not going to be more than a month or two that they're going to see a negative balance in their bank account. And then maybe we're looking at triggering foreclosure proceedings as a result of the mortgage not getting paid. Okay. And again, same thing too with insurance. If insurance isn't getting paid, suddenly we have no insurance on the property. So that's why this is such a helpful tool. And of course, one of the reasons why this court order exists in Edmonton and Calgary is that the courts have recognized that in these jurisdictions, there is delay, and they don't want, as a result of the delay of the courts, causing harm to estates out there. So the next thing, of course, as we talked about, put your client in touch with a lawyer that handles both estate law and real estate. Okay. So examples of terms and conditions. So one of the things that is very unusual about this is you're actually going to have a seller's condition. So buyers will have the usual subject to, financing, subject to inspection, anything else, okay? But we're going to have for the seller a condition that says subject to either obtaining a grant of probate or obtaining a court order permitting sale of property. And that is very critical because, of course, we're always looking at protecting our clients, protecting the seller, which is the personal representative and the estate in this situation. So we know that while it's likely that the court is eventually going to grant a court order, we can never guarantee it. So we always put in a condition so that way, if say out of the woodwork, you get, great Uncle Henry, who's now saying, well, that will was falsified and somebody was holding a gun to, the deceased's head, or you have somebody who alleges that maybe they were suffering from a delusion, maybe they were suffering from dementia, and suddenly it gets contested. Well, how you protect that personal representative is making sure that there's a condition. And then that way, if the condition isn't met, the deal is dead. And then you're not worried about the buyer suing the estate. Okay. So very, very, very important to have that seller's condition in there. Now, if you're working on somebody who says, well, I need to get this turned around really quick, and you don't have time to call a lawyer and say, hey, how would you word this term? Your get out of jail free card, your lifesaver, as I pointed out at the bottom of the slide, is of course always subject to seller's lawyer's review. Super critical. Okay. And we've got some other things in here. Sometimes, if we have found a party that a potential buyer that says, we're not in a big rush, so whenever you get the grant, that's fine. We can actually say that instead of a specific closing date, we're going to say the closing date shall be 2 weeks after the seller's lawyer has received a grant of probate. And so that's a term that we can put in. But by and large, you're going to be using the condition for the most part, because most buyers are going to want a specific closing date. They're not just going to be comfortable whenever this happens, right? And that's the reason why we are able to go out and get a court order, because we can say to the court, look, this house deal is closing on April 1st and it is March 15th. Story court. This is why we need to jump to the head of the line and get this court order, because there is a deal on the line here. So I want to give you an example of what the timeline looks like. So I just randomly picked April to May. So April 1, we have offer accepted. April 15th, the buyer's conditions are waived. April 30th, the seller's condition, meaning whether it's me or another estate lawyer, has gone out and got that grant or the court order permitting sale of property. And then, of course, May 15th is our closing date. So we're looking at a 6-week turnaround, all in all. And the reason why I like this 6 weeks, of course, is because the buyers are probably going to need a couple weeks to deal with financing, inspection. The 2 weeks after they waive conditions gives me, as the estate lawyer, more than enough time to do my application to the court, to get it filed and back. And then, of course, we always like, between conditions being removed and the actual closing date, a good 2 weeks to make sure that we get our conveyancing instructions, prep the file, meet with the client, make sure that we get our documents over to the buyer's lawyer in plenty of time for them to review our trust conditions. Okay. So I'm going to give you a bit more information about what the process looks like. I don't expect you guys to have much in way of questions about this, but this is just more for your information of what it looks like from the legal perspective when a client is dealing with a lawyer, what the actual meeting is like. So a grant application is just a really big, long application form with a bunch of schedules that need to be filled out. Of course, the court has to review it, and if it's accepted the first time, again, as I said, usually it takes 6 to 12 months. The 3 stages we kind of look at is the first initial information gathering stage, where we're trying to figure out what bank accounts the deceased had, who the people are who are receiving funds, who's in charge, etc. That can take a long time because some banks are really slow at getting us balances as of date of death. Okay. Then we actually submit it, and it sits in a queue with a surrogate clerk to review. The clerk reviews the files, makes notes on it, and then it gets sent up to the justice for review. And if the justice says, okay, looks good, the grant gets issued. And then we, if we can do it online, get a PDF copy. This is very exciting. Again, we get an actual PDF document. That is the new grant. Of course, under the old paper process, you get one with, the signature and usually a stamp from the clerk of the court. Not the case anymore. Okay. But if you don't get it right the first time, you make corrections, and guess what? It goes back to the bottom of the pile. So that can add potentially 3 months on. So again, why we like this this court order application is that if there is an issue with the grant, and it's going to take a bunch of time, at least we've managed to get the house sold, okay? Because that is usually the biggest panic that personal representatives have, because it's just sitting there and it's costing the estate money, and the beneficiaries are grumbling and saying, well, what are you doing to try and get rid of the house, so at least we're not paying for mortgage, insurance, property tax, utilities, so on and so forth, okay? So again, I have a little bit in terms of what my process looks like. So if ever you're talking to a client, they're like, well, I don't even know, like, what does the lawyer do? You have an idea here. You're saying, okay, well, they're going to do a general consultation with you. They're going to do some information tracking, try and get information from the banks. That's going to take a few months. Then eventually you're going to sign that application, and then it's going to get submitted to the courts. And once the court's okay, you'll meet with the lawyer again, and they'll give you the grant. Okay. And so I've got some kind of rough estimates on timelines there. I think the quickest I've ever gotten a grant back was a week. And in terms of the full process, that took about 4 months, because there's still that information gathering stage that the lawyers get bogged down in, because we rely on other parties to give us information, hopefully in a reasonable period of time, but that doesn't always happen. Okay. So it's sometimes a lot of follow-ups, a lot of phone calls, a lot of additional letters to get that information. Of course, oftentimes clients will have questions. Classic lawyer response, I know, because everybody just wants a number. It depends, okay? The clerk filing fee is usually around the $525 mark, but on the smaller side of estates, it might be $400 if you need a whole bunch of copies, which is not a thing anymore because we now have digital grants, so it's the same PDF over and over again. Unlikely it would be more than $525. Maybe we have to advertise for creditors and claimants. Maybe you have to get an accountant involved because maybe there's multiple properties, or maybe there's a residency issue. Maybe they had some time in the US or another country. Guidelines in terms of what lawyers charge, we usually charge, and this is a guideline. Again, we're free to depart from it, but this is what the surrogate court committee has recommended, is a base fee of $2,250 plus 1% of the gross value of the estate, assuming it's more than $150,000, which generally, if there's a house, it is. Or if it's less than $150,000, it's 0.5%, which you might see with a condominium, for example, if that's the really only the actual asset in the estate. Maybe you have like a $95,000 condo and maybe $5,000 in the bank. And so maybe that person's estate is. So then you can give some recommendations. But again, lawyers are free to depart from that. But this is just more information. So should your client have some questions, you might have a bit of background and say, well, this is what I've heard, but by all means, reach out to an estate lawyer and you can ask them what their fees are going to be. Okay. Now, the last thing I wanted to just touch on, just very, very briefly, are powers of attorney. So you have a seller with dementia, or in the case of maybe an immediate power of attorney, they've got capacity, but they're in a long-term care facility or hospital. They're not going to be signing any documents, but they've got that immediate power of attorney that allows the person that they've named to write any contract, any conditions, offer, etc., in order to sell the house. Okay. When you're dealing with somebody who has an incapacity issue, the critical thing that often gets missed is an original doctor's letter putting that power of attorney into effect. When we submit this stuff in terms of the transfer paper to land titles wants to know why somebody other than the seller on the title is signing documents on behalf of them. Hence why you need to submit the power of attorney, but you also need to submit that doctor's letter confirming that it's because the power of attorney has been put into effect because they have Alzheimer's or dementia or whatever disease that might affect their capacity. Okay. So just when you're meeting with clients, it's never just getting the power of attorney, although that's a great first step. It's also, if you're dealing with an incapacity issue, getting that doctor's letter. Very, very, very critical. Okay. And then basically that concludes my presentations. I've had a great time speaking with you. I know we covered a lot of information in this very, very quick session, but if you have any questions, by all means, you've got my contact information there, and I am available right now. I'm going to end my presentation and stop sharing my screen so I can go back and have Alex lead any questions that there might be.
Ooh, sorry. Oh, now I have my video off. There you go. Look at that. Perfect for a podcast. No video for me. So we do have a couple of questions. So the first one is, for the Probate digital service, what qualifies as a valid will?
So valid will means you can either, and I really do not like to talk about holograph wills, but I will for the context, meaning, of course, a will that is written that appoints a personal representative is like actually written out. So no video wills, no scrap pieces of paper, and is signed by the deceased plus 2 witnesses. That is what's called a formal will. A holograph will or an informal will is entirely in the deceased's handwriting. And of course, that's the thing, is that it has to be. So will kits are not in the deceased handwriting. And so as a result, they don't qualify for this process in terms of the online submission. You can still get a court order to sell the property. It's just, it's got to go the old paper route because you have to validate the will with the courts. And actually, I have one before me right now where unfortunately the deceased went out, got a 1-page will kit. It doesn't even name a personal representative, just says leave everything to my mother. Which is nice, but again, no 2 witnesses, so not the requirements of a formal will. We'll have to get it validated by the court. It's going to be a pain. So this might also be my plug of, please don't use a will kit. If you're ever talking to clients, trust me when I say the amount that they'll pay in legal fees to get a proper will done by an actual lawyer is going to be far less than the legal fees that they're going to pay to a lawyer to have a will kit validated. Okay, so food for thought.
Yup, I agree 1000% with that.
Thank you, Alex.
Yeah, unfortunately, you see family true colors at the end of a person's life. And so having that legal document, all the T's crossed and the I's dotted, is incredibly important. We do have another question that relates to the power of attorney. Is a copy of the doctor's letter sufficient, or does it need to be original?
So the reason why I want the original is because I'm going to make a certified true copy to go down to land titles. So under the Notary Publics Act, in order for me as a notary public to make a certified true copy, I have to see the original. So that's why it's got to be the original. Now, the original will go back to the client. I won't keep it, but in order for me to make that certified true copy to go down to land titles, I have to see the original.
Would a certified true copy work?
Yes, if you have a certified true copy from another lawyer, that's great, but that original certified true copy will be submitted to land titles. Land titles will not accept a copy of a certified true copy. So just as long as that's clear.
Yep, nope, that makes sense. This isn't written down here, but I thought I might as well ask it. What is the one thing you see that derails estates the most?
That is a good one. The one thing that I see that derails estates the most, honestly, is appointing somebody who's not up to being the personal representative. Truthfully, that's usually where our delay ends up coming in, is that the client says, oh, I'm busy. Oh, I'll get back to you. I'll get back to you. And, I sometimes have estates that come to me where the deceased has died 2 years ago, and now the personal representative is just starting to deal with it. And don't get me wrong, having lost both my parents, I do appreciate that there is a mourning period of time, and probate is a slow process to begin with. So there's certainly no rush, and having to kind of put your emotions aside and delve right into this. But that is the thing that I usually see, is that, okay, we're already kind of coming at this with a bit of delay already. We're dealing with some frustrated beneficiaries. And when there's frustrated beneficiaries, they've usually let that frustration be known to the person who's in charge. And that might actually end up being one of their own siblings. So there's usually some hurt feelings, and that's hard to surmount. Once that has happened, there's things that have been said that of course can't be taken back. So I'd say that's usually the most problematic part of state administration.
I again agree with you, because in my time, the one thing I've seen is parents making one of their kids the personal representative, but they have multiple kids, and then it just creates a lot of tension and problems within the siblings. When's the money coming? You're not doing enough. Mom and dad didn't want this, they wanted this. So it really puts that personal representative in a difficult position. So, and they were picked just because they're the eldest sibling or the most responsible sibling.
Yes,
Yeah.
yes,
So,
yes.
yeah. Yeah, so picking your personal representatives is incredibly important to ensure that you have a proper estate, and actually making sure that you have your will completed properly, and forget the terminology you used, but to make sure it's valid.
Yes.
One last call for any questions before we end today's webinar / podcast. So follow us on YouTube. This will be posted live, posted on our YouTube channel, Maxwell Devonshire Realty / education webinars. It as well is going to be on our new podcast, Maxwell Devonshire Realty. And it, of course, is playing live on our Facebook channel right now, Maxwell Devonshire Realty. So thank you so much for everyone that attended. Thank you again, Jennifer Locke from River Rock Law. It was a pleasure to have you on today. Your information was incredibly valuable, and I was right. Everything you said is what I'd be recommending. So boom, we're on the same page, which is always fantastic. Otherwise, hope you're having a great day, everyone, and see you guys later. Bye.